Every time I think Blake Lively actually has some really strong arguments here, it's like Justin Baldoni walks in and says, "Hold my kombucha," and then we see another round of stellar 4D chess. I have no idea whether or not he actually drinks kombucha. Grok made it seem like Baldoni's more of a celery juice guy, but you get what I mean. Anyway, I'm talking about Blake Lively's motion to dismiss and Justin Baldoni's opposition to her motion to dismiss, which he recently filed on April 3rd. In my last video on Lively's motion to dismiss, I talked about the legal privileges that she asserts in her efforts to dismiss his defamation claim. And my takeaway at the end was she's probably not likely to win on every single one of these arguments, but there's enough here to make me think that she could make his defamation claim against her go away. But now Baldoni's lawyers have once again shown how brilliant lawyering can completely change the story arc of this litigation. And now I think that at the end of this round, we're likely to see that Lively's motion to dismiss has probably just strengthened Baldoni's claims. Watch until the end to find out why I think so. Let's get into it. So once again, if you are new to this whole subject and you need some background on it, I have a whole playlist of videos linked in the description below. I really recommend starting there if you haven't been following every twist and turn, but you still want to jump into the subject. Otherwise, let's dive in. So in her motion to dismiss Justin Baldoni's First Amended Complaint, Blake Lively points to the statements Baldoni says are defamatory and argues that they're actually protected by at least one of three privileges. Those are what she calls the California Sexual Harassment Claim Privilege, the Litigation Privilege, and the Fair Report Privilege. Note that in my video on Ryan Reynolds' motion to dismiss, he didn't claim any of those privileges. That's because he can't. And that's because all of these privileges, at least in the way that Lively is asserting them, are intended to protect someone who is making a legal claim against someone else. But Reynolds hasn't filed any kind of claims against Baldoni, or in any way stepped into the role of a plaintiff in this whole saga. And the same is true of the other so-called Lively parties aside from Blake Lively herself, the Sloan parties. So these privileges really are only available to Lively to assert in the first place. And that's really important because in Baldoni's opposition to Lively's motion to dismiss, we see some really brilliant wizardry by Baldoni's lawyers. And by that I mean we see a new argument by Team Baldoni about Lively's liability here. It's called vicarious liability. Baldoni's legal team says that Blake Lively is not just liable for her own statements that she herself made. They say she's also vicariously liable for the liability of her agents, namely the other defendants in the lawsuit. And that's huge because it means no matter what the judge decides about these other privileges, if he decides that Baldoni can proceed with this theory of vicarious liability against Lively, it means Baldoni can hold Lively responsible for the allegedly defamatory statements by all of these other individuals. So in other words, let's hypothetically say that Judge Lyman says none of the statements in the CRD complaint can serve as the basis of defamation liability. With vicarious liability alleged, that doesn't mean that Lively gets to dismiss the defamation claim against her entirely. That's because she still has to worry about all of these other statements that these other people made allegedly on her behalf as her agents. But before we get too far ahead of ourselves, let me first explain what vicarious liability is and a little bit of what's required in order to assert it. Normally, the default rule is no one walking this earth is legally responsible for the acts of anyone else. What someone else does with their free will is up to them, and even if I have a very close relationship with them, I'm not legally responsible for what they themselves did. However, there are some exceptions to that rule. Agency is one of them. If someone hires another person to work for them, the person that is hiring them is the principal, and the person who's been hired is the agent. If the agent is performing their job duties for the principal, and just as part of their job, they do something that harms a third party, there is a possibility that the third party could hold not just the agent responsible, but also the principal. So think of it like a trucker that's driving for a shipping company. They're driving across the country and they don't do anything necessarily against company policy like drinking and driving or something, but they get a little tired because they're on a tight schedule and they've been forced to give up some needed sleep, and as a result they get into an auto collision. The people in the other car probably sue the driver and the shipping company because the driver was working for the benefit of the shipping company when he collided with the other car. So what Baldoni is alleging here is that Sloan and the Sloan parties are agents of Blake Lively, both literally and legally. They were hired precisely to be her personal relations agents and to talk to the media on her behalf and for her benefit. And they made statements to the press on Lively's behalf, both on and off the record, that Baldoni says are defamatory. Honestly, that's a pretty solid argument for defamation agency. It's also notable that it's the same logical reasoning that Lively herself is using to sue Baldoni and the other Wayfarer parties for defamation for statements made by Brian Friedman to the media. That was one of the things that she added to her claims when she amended her complaint back in February. And on all sides, both by Baldoni and by Lively, this is all pretty solid reasoning for asserting an agency theory of liability. Now, Baldoni also says that Lively should be vicariously liable for the statements her husband, Ryan Reynolds, made to WME, the alleged Baldoni is a sexual predator statements around July 2024. And although there's nothing to suggest that she specifically hired Reynolds for that purpose or anything like that, we can still look around at circumstantial evidence about their relationship and how they do a lot of professional crossover with one another. And it makes sense that they would be a team when talking with people and entities like WME, who at the time represented basically everyone involved in this litigation. So there's a good argument for Reynolds also acting as an agent of Lively when he allegedly made those statements. So in my opinion, the reasoning here fits very well, and best of all for Baldoni, it provides essentially a backup theory of liability for successfully suing Lively for defamation in the event that all of her direct statements get tossed out of this lawsuit. And so I really don't see how she gets kicked out of this defamation claim now. The only argument that she might have some success on at this particular stage is the fact that this is a new argument by Baldoni. They have not made this argument before filing this opposition. They do make the factual allegations that these various statements were made and that they were made on her behalf, but they don't assert the legal theory that she made these statements through these people as her agents. But I'm going to talk more about that specifically in a bit, so watch until the end for more of my thoughts on what I think will happen on this particular issue. Trust me, I think you might find it pretty interesting. Anyway, so now Baldoni also specifically addresses the legal privilege arguments that Lively makes in her motion to dismiss, and even in those arguments, we see some very good lawyering that shifts the analysis on the issue, in my opinion, in favor of Baldoni. So let's start really quick with the so-called California sexual harassment claim privilege, as Lively calls it. This is California Civil Code section 47.1. This basically says that anyone who makes a claim of sexual harassment in the workplace without malice is protected from liability. Basically, that means if someone made a good faith claim, they can't be held liable for defamation. Now, I did talk about this in the first video, but there are some things that I really should have clarified a bit better. What I pointed out in the first video on this topic was that an essential piece of this statute is that to claim the privilege, the sexual harassment claim needed to be made without malice. And I said, well, Baldoni alleged actual malice as he needed to as a public figure. And because of that, this really can't be dismissed at this stage with this particular argument. Let me explain that a little bit better here. Remember that Baldoni has alleged his defamation claim, and so if all of this goes to trial, he's going to have the burden of proving every single element of defamation. That includes the element of actual malice, his allegation that Lively knew that what she was saying was false, or that she was at the very least reckless as to the truth or falsity of the statement. Lively, however, has just asserted this privilege as what we would call an affirmative defense. An affirmative defense is more than just a regular defense. A regular defense to defamation would be something that basically attacks the plaintiff's ability to prove one or more of the elements that they need to prove in order to win on the claim. So an example of a regular defense is Reynolds' claim that his sexual predator statements were just his opinion, man.
Yeah, well, that's just like your opinion, man.
This argument really is just attacking the element that Baldoni needs to prove, showing that the statement is a false statement of fact. And that's why it's a basic defense. An affirmative defense, on the other hand, is something that you would often call a legal excuse or justification. Self-defense to murder is an example. A defendant in a murder case might say, yes, I killed that person. However, I was legally justified because I was actually afraid that this person was about to take my life, and my fear was reasonable. So in this case, these privileges that Lively asserts are also affirmative defenses. They're not attacking the elements of defamation, but saying there's a separate legal reason why I shouldn't be held liable for this. And the thing about affirmative defenses is when a defendant asserts an affirmative defense, it's usually the case that they have the burden of proving that affirmative defense. So if Lively is asserting that she is entitled to protection by California Civil Code 47.1, she needs to prove that she made the statement or statements without malice. And how does she do that? With evidence. And that leads us to what I talked about in that first video about issues of fact versus issues of law. When we talk about issues of law, we're usually talking about things like legal standards. For example, does the law generally allow someone to hold another person responsible for this kind of thing? As a more specific example, can I sue my boss for just being an a-hole? Or do I need to show a little bit more, showing that it was on the basis of something like my race, my gender, my religion, etc.? As another example, does the law allow someone to have waited this long before filing their lawsuit against the defendant? It's usually those kinds of questions. And those questions are properly answered by what's called a trier of law, also known as the judge. Then there are issues of fact. This is where we're weighing one side's evidence against another side's evidence. We're looking at what is more likely of an explanation as to what actually happened on this date. What do we think that this person was thinking at the time? Those kinds of questions. And because answering those questions requires a person to weigh some facts against other facts, those are questions that are generally answered by what's called a trier of fact. And in cases where a jury trial has been requested, the trier of fact is the jury. And no judge wants to take away a case from a trier of fact, especially a jury, unless they have to, because say no reasonable jury could possibly conclude one way or another. So like I said a moment ago, Lively has to prove that she is entitled to this privilege, which protects people who make sexual harassment claims without malice. And that means she needs to prove it with evidence. Facts, which means ultimately that is a question for the jury to decide. And so at the stage that we're at right now, the only way for this particular argument to lead to the dismissal of the defamation claim is if Baldoni didn't successfully plead all elements, and including especially something like actual malice. But he did. And all of those elements are covered. So it's enough to survive a motion to dismiss, at least for this particular argument. Anyway, that's the sexual harassment claim privilege. Reading Baldoni's opposition, what he says in response to Lively's assertion of the litigation privilege and the fair report privilege also totally shifts the analysis in his favor, in my opinion. Let's start with what Lively argues first. As a reminder, the litigation privilege protects a person from liability for things that they said in the course and scope of either pursuing or defending against legal claims. And the reason for that is because litigation is inherently an adversarial process. One side says one thing, and the other side is entitled to respond right away and in equally strong fashion. So in litigation, the likelihood of unjust reputational harm is super low because both sides have every interest in putting their best case forward and responding to what the other side has to say, and the people listening in, i.e. the jury, also have an interest in listening to the whole story in the interests of fairness. This all isn't necessarily the case in the court of public opinion, of course. So Lively argues all of her alleged statements are covered by the litigation privilege because they come from the CRD complaint, and she submitted the CRD complaint to the California Civil Rights Division to obtain the right to sue notice, and then she eventually sued for these claims in federal court in New York, but under California law. And obtaining that right to sue is a necessary administrative step in being able to sue for these claims under California law. Now, as I said before, the right to sue notice is a necessary administrative step under California law. As I also said, you don't need to submit a whole substantive complaint in order to fulfill that step. But she did that as part of the process. And although she waited a few weeks, she did eventually sue under those claims. Now, I did point out that the CRD complaint is a pre-litigation communication, and under California law, pre-litigation communications are only covered by the litigation privilege if at the time the statement was made, it's made about litigation that was contemplated in good faith and under serious consideration. And whether that's the case is considered another issue of fact for a jury to decide. So there's a good chance that this defamation claim under this particular argument still survives at least until a jury can look at it under the best of Lively's arguments. However, Baldoni's side points this out, that it is an issue for the jury to determine, but they also make some other arguments that really weaken this litigation privilege argument overall, in my opinion. The first thing they point out is, we're not even talking about the CRD complaint. They say the CRD complaint is not where you find the statements that Lively made that gave rise to her defamation claims. The statements she made were statements directly to the press, both herself and through her agents. This means Baldoni is arguing that the allegedly defamatory statements Lively made were outside that bubble of the litigation privilege. Specifically, they say the communication must function as a necessary or useful step in the litigation process and must serve its purposes in order for it to be covered by the litigation privilege. And this is true of the standards of the litigation privilege. So if the allegedly defamatory statements were in fact coming from the CRD complaint, Lively would be better able to assert the litigation privilege. That's because, like I said, it was submitted to the California Civil Rights Division for the purposes of obtaining a right to sue notice, which is a necessary step in the whole process. Now, there can be disagreement as to how necessary the substantive complaint was for that process, since, like I said, you don't really need to submit a substantive complaint to obtain the right to sue notice. However, it's at least aimed in the right direction, so an argument can be made that it still fits within the definition of a necessary or useful step in the litigation process, and that it serves the purposes of litigation. But here, Baldoni's saying, no. That's not what's going on here. We're not suing you over the CRD complaint. We're suing you for everything you said to the press, to WME, and to other people around that CRD complaint. And as Baldoni points out, filing a lawsuit is protected by the privilege, and even sending a demand letter is protected. But communicating with the public or the press is not protected by the litigation privilege, even where it advances the litigation by rallying the masses. So yeah, if Baldoni's side is saying that they're not suing over the statements that arise out of the CRD complaint, that really takes the sails out of Lively's argument for the litigation privilege here. Because how can anyone argue then that talking to the New York Times was a necessary or useful step in pursuing legal claims in court? You really can't. The only way to really protect those statements then is under California's standard for the fair report privilege, which brings us to our next stop. Okay, so quick refresher on the fair report privilege. As everyone in this litigation seems to agree, the fair report privilege is typically reserved to protect the media fairly and accurately reporting on legal proceedings. As an example, the New York Times receives a copy of a complaint for a hot new lawsuit that has just been filed, and they report fairly and accurately on basically what the complaint says. They're protected from defamation, even if they've just repeated some things that otherwise could be defamatory. But in California, it doesn't just protect the media in that situation, it also protects whoever sent the copy of the complaint. As I've talked about before, in some other states like Texas, where Jed Wallace filed his lawsuit against Blake Lively, that isn't necessarily the case. There, the Texas Supreme Court has said, nope, as soon as you publish a copy of the complaint to a website or you send a copy of it to the media, you're republishing those statements outside the litigation context, and now you're exposed to defamation. In other words, they say, let the media find it on its own. If you help them with that, you are implicating yourself. And so here, Lively was again saying the CRD complaint was leaked to the New York Times, and that's all covered by the fair report privilege. And honestly, after researching California law on the subject, I kind of agreed with that based on the idea that Lively's allegedly defamatory statements came from the CRD complaint. However, again, Baldoni says that's not where all these claims come from. But they also say, even if they were, you still wouldn't be entitled to this privilege. And here's why. First, they say the fair report privilege by definition only applies to communications relating to an official proceeding. And aside from the CRD complaint issue, Lively has a timing problem here. And this is probably one big reason why Baldoni's side has been harping on these dates again and again and again since the beginning. They've been making a huge deal of this from the start. They say, as alleged, Lively, Reynolds, and the Sloan parties started working with the NYT months before the CRD complaint was filed. Indeed, the NYT apparently started working on its story, fed by Lively and her co-conspirators, as early as October 2024. Lively did not file her CRD complaint until December 20th, 2024. The crux of the FAC is that Lively worked hand in glove with the NYT throughout the fall of 2024, feeding its reporters defamatory statements and coordinating closely with them to ensure the end result would amount to a kill shot to the Wayfarer parties' reputations and careers. This had nothing whatsoever to do with any then ongoing judicial proceeding. And then to hammer it home, they say, at the time they were made, these statements bore no relation to any judicial proceedings, and they are therefore ineligible for the protections of a privilege predicated on the pendency of such proceedings. Okay, so what does all of this mean? Remember, the Fair Report privilege protects publications that are fairly and accurately reporting on legal proceedings. But as Baldoni points out here, there need to be legal proceedings that actually exist in order for there to be a fair and accurate reporting of those legal proceedings. And we're not just talking about a week before she obtained the right to sue notice, the draft of the CRD complaint was ready for submission to the CRD, and all they did was just a media push for the document to inform the press that they were about to submit this to the California Civil Rights Department and go on for litigation afterwards. Baldoni says, no, this was months and months of communication between you and the press long before you started even any kind of official pre-litigation process. And so now there really is just one question, which is what exactly were these communications between Lively and our team and the press? Because if it literally was just an email from Sloan attaching the CRD complaint and saying nothing other than Blake Lively plans to submit this to the California Civil Rights Division and then file a full lawsuit right after, then maybe this is protected by the Fair Report privilege. But as alleged, the communications between Lively and our team in the New York Times, and maybe even others, is way more involved than what's typically covered by the Fair Report privilege. And so because Baldoni has clarified that the allegedly defamatory statements aren't coming from the CRD complaint, and because the back and forth with the press allegedly started months before she got the right to sue notice, and because it's allegedly very substantive communications, we're not talking about your basic all I did was send a copy of the complaint to the press situation, which would normally be covered by the Fair Report privilege. So now in order to side with Lively here, we would have to know what the actual truth is of what actually happened behind the scenes with these communications between Lively and her team and the press. So we need to look at the evidence. And you know what that means? It's an issue of fact for the jury to decide, which means it is not likely to be dismissed at this stage. So now that it looks like Baldoni has responded to Lively's arguments with what I think are really strong counter-arguments, we get to the part where I think that Lively really just made Baldoni's case even stronger. Remember how at the beginning of this video, I talked about how Baldoni asserted in his opposition that Lively is also vicariously liable for the statements that the other defendants made. Well, I also mentioned earlier that this is a new assertion that we haven't heard from Baldoni and the Wayfarer parties before this opposition. And really, vicarious liability is something that needs to be specifically pled in the complaint in order for the plaintiff to pursue it. So I expect Lively's team to respond by saying this is a brand new theory of liability, and you can't just assert it in an opposition to a motion to dismiss. It has to be in the complaint, and therefore you lose. Really, what I think is going to result from all of this is that the judge is likely going to tell Baldoni and the Wayfarer parties that if they want to hang their hat on vicarious liability as another theory of liability, they're going to need to amend their complaint again to add that allegation. And really, it's early enough in the litigation that there really shouldn't be much of an issue with allowing them to amend it to include that. So now Baldoni is probably going to go back and file a second amended complaint alleging more basis for liability against Blake Lively. And that means this is just another avenue for holding her responsible for any number of these statements. And like I said in my video about Ryan Reynolds' motion to dismiss, sometimes filing a motion to dismiss can be a huge mistake because you could just give your opponent the opportunity to clarify and strengthen their claims and maybe even allege even more. And this looks like yet another example of that.
You blew it. Capiche?
But those are my thoughts. What do you think? Did you have the understanding from Baldoni from the beginning that the CRD complaint wasn't any basis for the allegedly defamatory statements? Or was I just being a little bit of a dum-dum for missing that crucial detail from the start? Because I definitely was under the impression that a lot of this was coming from the CRD complaint until this opposition. Like I said before, there are a lot of details in this case and it's easy to get lost in the weeds. But Let me know what you think in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics like this one, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.